Well, good afternoon, everybody. I'm Mike Farrell, and I have the pleasure of presenting today's Lunch and Learn, how other state medical boards operate the common, the uncommon, and the uncommonly odd. What I want to do over the next 30 to 35 minutes is give you a brief overview of how other state medical boards operate and then how we compare. State medical boards essentially do the same thing. They license MDs and other professions, and they discipline those licensees. But there are some interesting differences in how they do their business. When I go to national meetings, one of the things I like to do is talk to people from other boards and find out how they operate. And I always find out something interesting that makes me reconsider or think about the way we do things in a new way. Sometimes my assumptions are challenged, and sometimes when I find out something about another board, I think to myself, that's just a little odd. If you have any questions today, please put them in the chat, or you can save them to the end. If you put them in the chat, one of our crack staff may provide an answer for you. So there are a lot of features of state medical boards to talk about, but in my research, I decided to narrow it down to just these topics. And I chose these topics because they either demonstrate a stark contrast between the way we operate and the way another board or group of boards operate, or they provide some interesting tidbits. So we'll talk about size, and I will tell you why we're one of the largest boards in the country. We'll talk about composition, what boards are made of, and I'll talk about how some boards require certain people, types of people to be on their board. I'll talk a little bit about what professions some boards regulate. I'll talk about autonomy or independence of the board. I'll say a little bit about the complaint process and talk about some boards who aren't nearly as involved in discipline as you are. I'll say a little bit about transparency, and then I'll turn to a topic that is a favorite of some of yours, and that is compensation. And then I'll end with a few odds and ends. So let's get started. Let's talk about size. The vast majority of state medical boards are run between about 7 and 15 members. There are a few that are smaller and a few that are larger. Size doesn't necessarily correlate with number of licensees in a state, however. For example, West Virginia has a larger medical board than California and Illinois. In Washington, by the latest numbers that I looked at, we rank about 15th in the number of physicians practicing in our state, and yet we're tied for 3rd for the largest board in the country. We're tied with Connecticut. So you're probably wondering, well, why are we so big? Well, there's a historical reason for that. And it's because back in 1881, the legislature created the Board of Medical Examiners. This is 8 years before statehood. And then about 70 years later, the legislature grew increasingly frustrated with the Board of Medical Examiners' lack of discipline. So in 1955, they created a separate board, the Medical Disciplinary Board, which eventually grew to 13 members. So we had, for a number of years there, a licensing board and a disciplinary board. And sometimes the communication between the two boards was not ideal. There was a case that I was told about in the late 1980s when the disciplinary board suspended a physician's license, and then the licensing board renewed that physician's license. He went immediately to the newspaper, who published an article with a picture of him standing there smiling, holding up a copy of his physical license and saying, "Look at me, I got my license back." Well, that caused some embarrassment, of course, to the two boards. Then in 1994, unrelated to that story, the legislature created several commissions, and one of them was the Medical Quality Assurance Commission. What they did was they combined the licensing board and the disciplinary board and solved a lot of problems. They just added the 6 to the 13 and came up with 19. I remember having a lot more chairs in the room when the commission first started meeting. Then in 2006, the legislature enacted major malpractice reform, and there were a lot of aspects to this. I don't know if you remember the dueling initiatives back then, 330 and 336. the legislature made a number of changes to the malpractice system, and as a little piece of that, they decided that they would add 2 public members to the commission, increasing the number of public members from 4 to 6, that was important in enacting medical malpractice reform. And that's how we got today's number of 21. So you're probably wondering, well, who's bigger? Who's bigger than us? Well, if you know your state shapes, you can tell, oh, that's Maryland and New York. The Maryland Board of Physicians has 22 members, so they have 1 member more than we do. And the New York board has 112. Now, I know some of you are wondering, did I hear that right? Is my audio working? But yes, I did say 112. And so you're probably wondering, well, how can they hold meetings? How can they fit in one room? Maybe most importantly, who handles the meals? Well, let me explain how New York works. They actually have 2 boards. They have the New York State Board of Medicine, which is the licensing board, has 25 members. By themselves, they'd be the largest. And then they've got a board with a funny name, the Board for Professional Medical Conduct, which is their disciplinary board. And currently, they have 87 members. So I added the 2 together to get 112. I happened to speak to a member of the Board of Professional Medical Conduct at a meeting a number of years ago, and she told me they had 100 and something members, and I was aghast. I said, how do you meet? And she said, well, we don't meet all together. At least at that time they didn't. They meet regionally and do their business by region in smaller groups. I found a report, the last report I could find from this board back in 2017, and in the report it said they have 62 committees. So if you think we have a lot of committees or a lot of members, just think of New York. So let's talk about composition. As you know, we have 13 MDs, 2 PAs, and 6 public members. Although we're big in size, our composition is fairly typical. And all of you have been appointed by the governor. So for almost every state medical board in the US, the members are appointed by the governor. There's a few boards in which most of the members are appointed by the governor, and 1 or 2 are appointed by their state legislatures or committees. In our state, although you're appointed by the governor, the pharmacy commission is appointed by the governor, but they have to have Senate confirmation. This is true about half the state medical boards. They have to have Senate confirmation. The pharmacy commission in our state is the only one that I'm aware of that requires Senate confirmation. And why that is, I don't know. Maybe somebody else knows. So there are 3 states that don't have gubernatorial appointments, and the first one is Nebraska. The members are appointed by the State Board of Health. In New York, the members are appointed by the Commissioner of the Department of Health or the State Board of Regents. And Alabama does it the old school way, which means the physicians in Alabama elect their members for the board. That's the way we used to do it many years ago. We had the physicians in each congressional district vote for their representative to the medical disciplinary board. And then we have a number of medical boards that in which they have certain types of people serve on the board. And I found some of them kind of interesting. In California, for example, they require that 4 of their MD members have faculty appointments with a state medical school. In Illinois, no more than 6 of the 11 members can be of the same political party. Similarly, in Iowa, no more than 5 of the 10 members can be of the same political party. Can you imagine applying for the Washington Medical Commission and having to declare your political affiliation? Well, there's 2 states in which they have to do that. Also in Iowa, 5 members must be male and 5 members must be female. I think the governor in our state tries to even out the gender of our members, but in Iowa, it's in statute. There are 5 states, Arkansas, Ohio, Tennessee, Florida, and Rhode Island, that require at least 1 public member to be over the age of 60 years old. How would you like to be the member of that board and be designated as the senior, being in the senior position? I guess I could be. In Florida, one member must be an international medical graduate and another board member must be a licensed healthcare manager. Rhode Island, interestingly, requires one of its members to be a plaintiff's medical malpractice attorney. Now, we have that, but of course, it's not required by statute. In North Carolina, one member must be a member of the Old North Medical Society. The Old North Medical Society is a society for African American physicians. New York requires one physician member to be an expert on reducing healthcare disparities among demographic groups, and another physician member to be an expert on women's health. There are several states that require the head of their umbrella agency or the designee to serve on the board. But in Idaho, the director of the state police or their designated agent is required to be on the board. And finally, in Nevada, they must have a member who represents persons who regularly provide healthcare to patients who are indigent. Let me say a couple things about public members. California has the highest percentage of public members of any state medical board. As you can see, 7 of their 15 members are public. And yet there's a strong push in California over the past few years to increase the number of public members and make it majority public members. There's a bill before the Assembly right now to do just that. Interestingly, California was the first state to have a public member, and they got it in 1961. That was controversial at the time. Physicians at the time nationwide said, how can a non-physician judge the conduct of a physician? Well, now it's normal, but it wasn't back then. In Washington, we got our first public member in 1975 when Nancy Nordoff Skinner was appointed to the Board of Medical Examiners. And then 3 years later, Governor Dixie Lee Ray appointed her sister, Marion Reed, to the Medical Disciplinary Board. We got our first PA member, of course, this is all by statute, in 1991 when Jan Paxton joined the Medical Disciplinary Board. However, the statute prohibited Jan from voting on MD cases. She could only vote on PA cases, and she was not happy. She expressed her unhappiness just about every meeting. PAs did get suffrage a few years later. More on public and PA members. The last medical board in the country to get a public member was the State Medical Board of Louisiana, the Louisiana Board of Medical Examiners. They got their public member in 2018. And if you think that's kind of late to the party, well, the Alabama State Board of Medical Examiners today does not have a public member. This comes with a little caveat. So let's take a look at Alabama. Alabama has 2 boards. They have the Board of Medical Examiners, 16 members, no public members, no PAs. They do almost everything. So this is the main board. They also have a separate board called the Alabama Medical Licensure Commission. And what they do is they're the body that actually issues the license. So the application comes in to the bigger board, the Board of Medical Examiners, who reviews the application and makes a recommendation to the Alabama Medical Licensure Commission. That commission also has a second function. They sit on hearing panels. It's a much smaller board, a much smaller staff, but this commission has 1 public member. Note that neither of these boards has a PA member, even though they license PAs. Alabama, however, does have a PA advisory committee that advises both boards. Some states have separate PA boards, for example, Arizona, California, Rhode Island, Utah, and Tennessee. There may be others. Most boards have term limits for their members. The terms typically are 3, 4, or 5 years. Those are the ones I've seen. And typically a member can serve 2 terms. There is at least 1 state they can serve 3, but there are 12 states with no term limits. I remember a notice I saw a few years ago about a member of the Texas board who was leaving the board after serving something like 27 years. So can you imagine working for the Washington Medical Commission for 27 years? I guess I can. Okay, let's talk about professions regulated. Here I'll show you a spectrum. Most state medical boards license both MDs and DOs. Only 13 states have separate MD and DO boards. So we're in the minority there, we're having separate boards. But of the other boards, most of them also license other professions. And here's where we find ourselves near the end of the spectrum. So at the end of the spectrum is the medical boards in Arizona and Utah. They each just license MDs. Then comes us. We license MDs and PAs. Maine does the same. Rhode Island licenses too, and it's MDs and DOs. And all the rest of the boards license essentially between 4 and 7 professions. So I'll just point out a few. California licenses four professions: MDs, midwives, polysomnographers, and research psychoanalysts. And this is where it gets to be a rather curious mix of professions. Oregon is one of several states that licenses 5. They license MDs, DOs, PAs, podiatrists, and acupuncturists. That's fairly typical. Then it starts to get a little curious. The Florida Medical Board licenses 5 professions, including dietitians and electrologists. And if you think that's strange, well, then buckle up, because the Oklahoma Medical Board licenses musical therapists. Now, Amelia Boyd is probably thinking, well, that's not surprising, because her home state is the home of a number of country music legends, including Reba McEntire and Blake Shelton and Garth Brooks, and her favorite group, the pop group Hanson. Our neighbors in Idaho license 7, and then as we move down the continuum, we get to Delaware. They license 11. I won't listen for you. I'll just say that one of them is acupuncture detoxification specialists and administrative medicine. But the winner is Kansas. They license 13 professions. They license MDs, DOs, chiropractors, podiatrists, rad techs, athletic trainers, OTs, PTs, respiratory therapists, acupuncturists, naturopaths, midwives, and contact lens distributors. Notice the name of the California board is the Kansas board is the Kansas Board of Healing Arts. Now I'll go on to autonomy or independence, and here's where it gets a little bit subjective. I put boards in 3 main categories. Some boards are independent of other state agencies. Most boards are right in the middle. They're part of some umbrella agency, and they have varying degrees of independence. And then we have a couple boards that are advisory in one respect or another. So I'll start at the more independent end of the spectrum and talk about North Carolina. North Carolina Medical Board is independent of every other state agency in North Carolina. They collect their fees, they decide how to spend it, they decide what employees to have, what to pay them. Their employees aren't even part of the subject to the civil service laws in North Carolina, because they're not considered to be state employees. Then we come to just about every other board, right in the middle. I would put us, maybe you could put us maybe on the more independent side. Most boards are part of an umbrella agency. So these boards have independent decision-making authority on licensing and discipline, but the umbrella agency covers certain functions, and there's a wide range of variability here. Some boards have their own staff and budget, and other boards do not. So the Connecticut board, for example, the Maryland board, their umbrella agency handles budget, personnel, and space. As we go further down the line here, we come to the Connecticut Medical Board. The Connecticut Medical Board has no budget. Everything is handled by the Connecticut Department of Public Health. They don't even have authority to adopt rules. And this surprised me in my research. I found a handful of cases in which the states do not have rulemaking authority. The umbrella agency does. The Connecticut board is advisory for licensing, but they do have independent authority on discipline. And then at the very end of the spectrum, we find the fine state of Nebraska. So the state of Nebraska, their medical board has no independent decision-making authority. It merely makes recommendations. So for example, when an application comes in, they review the application and then they make a recommendation to the CEO of the State Department of Health and Human Services. When a complaint comes in, the department investigates, they refer the file to the board to review it, and then the board makes a recommendation to the Attorney General's office. The board is purely advisory. The disciplinary orders that come out of Nebraska don't even have the board's name on it. They list the Nebraska Department of Public Health and Human Services as the party taking the action. So editorial comment here, we were threatened with this back in 2007, and we were able to avoid that fate. This is a similar fate that Nebraska's under. This is not where you want to be. Now let's turn toward processing of complaints and specifically board involvement. Most boards do their work by committee. For example, most boards have a licensing committee that looks at applications and decides whether to grant the license, or they make recommendations to the full board. That's what we do with Panel L. We started Panel L just a few years ago. Now we have a licensing committee like most boards. Most boards also have a disciplinary committee that handles discipline, and this is where we deviate strongly from most boards. Very few boards have the full board make decisions during the disciplinary process. So Oregon is typical. So let's take a close look at Oregon. Oregon has what's called an investigative committee. This committee looks at complaints, decides which ones to investigate, they guide the investigation, they can even call in the respondent during the investigation for an interview before the investigative committee. They can settle a case at that point, they can close the case issue charges. Actually, before they do all that, they make a recommendation to the full board. I had a chance to sit in on one of the meetings of the investigative committee a few years ago. I even sat in on a couple of interviews with licensees. I found it very interesting. Vermont is similar, except they have 3 investigative committees, one in the north, one in the south, and one in central Vermont. They decide what to investigate. They too can invite the respondent in for an interview. If they have hearings, they have a hearing panel of members of the board who sat on the other investigative committees. So if the panel in the north votes for a statement of charges, then that northern panel wouldn't sit on the hearing panel. As you know, here in Washington, we don't have a separate committee for discipline. The whole commission handles discipline. So each one of you has an opportunity to participate on CMT and review complaints and decide whether to investigate. And then each of you is assigned cases to review, and you can direct the investigation, consult with the investigator, and then you break up into panels and you present your cases at case reviews during commission meeting. And then if a case is charged or we offer informal disposition, you're in charge of settlement, and you're all involved in compliance. So you are all involved at each step of the process. And to fully appreciate what you have, we have to take a look at the other end of the spectrum and take a peek at California. So in California, almost every decision is made by staff or by the Attorney General's office. So for example, when a complaint comes in, staff reviews it and decides whether to investigate or close. The board is not involved. When the investigation is completed, staff decides whether the case should be closed or whether action should be taken. If they decide the case may warrant action, the file is sent to the Attorney General's office. The Attorney General's office then decides whether to issue a statement of charges, they call it an accusation, or close it. The board is not involved in any of that. Then when the case goes to hearing, the hearing is held before an administrative law judge. There's no panel, there's no board members. The administrative law judge hears the testimony, the arguments of the attorneys, then issues a proposed order. So you might be wondering, well, when does the California board get involved then? Well, they get involved at the very tail end of the process. When the administrative law judge issues a proposed order, that's when the board gets involved and looks at the order, looks at the transcript, and then they can adopt the order or change it. The only other place the California board gets involved is when there's a settlement. They review the settlement and adopt the settlement. So if you look at the way the California board operates and the way the Washington board operates, the Washington Commission, they're almost mirror images of each other. They're very different. So I mentioned that the California board has hearings before an administrative law judge. You may think that's odd. It's actually not. It's how the majority of boards operate. Their hearings are before an ALJ, and the ALJ issues a proposed order that the board then reviews. That's the way our friends in Oregon do it, and Idaho, and most states. There are a substantial minority, I counted 26 out of 70, who have hearings before their board members or a panel of their board. North Carolina, Iowa, Vermont, and Oklahoma are examples of that. However, not all of those board members in those states are allowed to ask questions of the witnesses. New York, I mentioned the Board of Professional Medical Conduct. They have a hearings committee. So it's that committee that sits for hearings. And Connecticut has a separate group apart from the board. So it's a group of people apart from the board whose sole job it is to sit for hearing panels. Let's turn to transparency. So this is an area that has seen a significant shift over the past 10 to 15 years. Medical boards are becoming more open and more accountable. Despite this shift, we find ourselves at one end of the spectrum. So you're probably aware that Washington has quite liberal public disclosure laws, and the Public Records Act and the Open Public Meetings Act, and then the case law that has come out has interpreted them very broadly. Once an investigation is authorized in our state, the fact of the investigation is public. So if somebody calls the Department of Health and says, is there a complaint against Dr. So-and-so? They'll be told yes. If they ask, well, what's it about? Well, then they'll be told, we can't tell you that. Most states don't operate that way. And our transparency has evolved over the years. It used to be that we did not release a copy of the file until charges were issued. Then because of court decisions, we started releasing a copy of the file. By we, I mean the Department of Health Public Disclosure Unit, as soon as the investigation was complete. And then another case came down, which said that in some circumstances, documents in our file are subject to public disclosure even before the investigation is completed. I am not aware of any other state that operates that way. In most states, the investigation, the fact of the investigation is not made public until charges are issued. So let me talk about a couple states. Tennessee, the investigative file is not released to the public until charges are issued, and the only parts of that file that are released to the public are the parts that support the allegations in the charges. Vermont is similar. A complaint or investigation is confidential until charges are issued or the case is settled. And the Vermont statute states that this is intended to protect the reputation of the licensee from the disclosure of unwarranted allegations. In some states, the investigative file is never made public, even after the case is closed. The file, of course, goes to the respondent upon charges, but it's never released to the public, and that includes Delaware, Iowa, Idaho, and New York. And at the very end is the state of Minnesota. In Minnesota, not only is the file never made public, but the hearings, the disciplinary hearings, are closed to the public. Now, this used to be true. I've heard of other states having closed hearings when I went to national meetings, but that has changed. Tennessee used to be closed. But Minnesota is the only one I'm aware of whose hearings are closed to the public. So Minnesota has awfully nice people, but they're not very transparent. So let's move on. We're almost done here. Compensation. I'm just putting it all up at once. As you know, you are reimbursed or paid $250 a day. I know that's not a whole lot. That amount was set back in 1994 when the commission was created. But there are 10 states that do not pay their board members anything. They reimburse them for travel, but they get nothing for their time. There are also 14 states that pay their board members $50 or less. There's a few that pay $150. Not everyone's listed here. Ohio pays its board members $157.60 per day. Why it's such an odd number, I don't know. I think they have some kind of grid that they fall on. We are now tied with Arizona, Maryland, Oregon, and Oregon at $250 a day, and we are exceeded, I believe, only by the boards in Alabama and North Dakota that get $300 a day. Finally, I'm going to end with just 3 odds and ends. Vermont interviews applicants. Every state used to do this. We used to do this. Maybe other states do it, but Vermont is the only one I know of that does personal interviews of its applicants. And frankly, I don't know how that works. I don't know what happens when you have a really well-qualified applicant who bombs the interview. Maybe the interview is about positive questions, yes questions on the application, I don't know. Arizona has 2 standards of proof. They have clear and convincing evidence for all cases, just like we do, except for sex cases. They have a lower standard, preponderance of the evidence. I find that interesting. And finally, I find it interesting the different models that boards have for getting legal advice or getting their legal work done. And there's essentially 4 different models. So some boards have just in-house attorneys. They don't rely on the Attorney General's office. So North Carolina is an example. They have what they call board attorneys who work for their board, and they handle all the legal work. And by all, I'm including tort claims. So the North Carolina board attorneys also defend tort claims. Our friends in Oregon don't have any in-house attorneys. They rely completely on the Oregon Attorney General's office. There are a number of states that have both, like us. They have staff attorneys, and they rely on the Attorney General's office to work together to provide legal advice. And then there's the most interesting model, I think, are boards that have neither. They don't have board attorneys in-house. They don't rely on the Attorney General's office. They rely on private attorneys. So I happen to know the attorney for the Arkansas Medical Board, and I know the attorney for the Mississippi Medical Board, and they work in law firms, but they devote a small portion of their practice to providing legal advice to the boards in Arkansas and Mississippi, including prosecuting their cases. So I'm going to conclude my presentation with a photograph that I took when I visited the North Carolina Medical Board back in 2011, I think it was. They have a pretty ordinary office devoted to their board, but at the end of the office, end of the building rather, is a very nice boardroom where the North Carolina Medical Board comes in and meets. You can see they have comfy leather chairs on a raised dais. The state seal is in the background, and they have 2 tables there, kind of like we try to set up for their attorneys and for their respondents. So I hope that you have found this presentation informative and interesting. I hope it's broadened your perspective a little bit, and I thank you very much for your attention.
Thank you, Mr. Farrell. So we have one question from Yan Ling, Dr. Yu, and she asks, does California get involved with decisions on whether and how to investigate cases?
They do not. They're not involved in that process at all.
And then Micah has his hand raised. Go ahead, Micah. You are self-muted, Micah.
I'm always self-muted.
There you go.
So yeah, just a couple of add-ons and an ask from Mike. So the first thing is with respect to the lay majority membership. There's in Europe and in the United Kingdom, there is an effort shifting most regulatory boards over to a lay majority membership. And so that is something that's ongoing. I anticipate we will see that working its way through the states here in the next decade or so. The other thing is, Mike, you've got the first picture of the North Carolina Medical Board, but I'm curious if you have the second one that you took from there, because I distinctly remember you telling me that when you sit in those chairs as a hearing member, there it is. That's what you look at when you are hearing a case at the North Carolina Medical Board.
Yeah, this is the, thanks, Micah. This is the back wall. So the board members, when they meet, they're looking back at a portion of their mission statement, which says for the benefit and protection of the people of North Carolina, which I thought was a pretty cool idea. So I took a photo of it.
And then we have a hand raised, and I'm going to unmute Micah and Jody, if you would like to go ahead.
So I had a question, and this might relate back to the North Carolina. I'm interested in optimal team practice, and it's been noted that North Carolina has the first PA program in the United States at Duke University. We are honored to have the second one in the state of Washington, and they are pushing through Senate Bill 345 for optimal team practice. And I was wondering what the state of Washington is doing to make that happen for PAs, because it seems as though we're going to start allowing foreign medical doctors through, and that might create kind of an issue for finding a collaborative physician or rotations for a student.
Can you unmute Micah?
Yeah, I'll address that. So that's an interesting bit of trivia. I did not know that we were the second program in the US. That's kind of cool to know. The first thing is, we are a creature, we being the medical commission, are a creature of the legislature. They created us, they tell us what to do. And in this case, the legislature has had multiple proposals put forward to them, most of which we have supported, about creating a more aligned version of PA practice for optimal team practice. They've rejected every single one of them. So I know that the PA Association, WAPA, is putting forward something else next year that is going to be a bit more comprehensive, and they are working with the various stakeholders to negotiate what can be agreed upon in the state. I also know that in meeting with my counterparts in Oregon and Idaho, that they have sort of advanced their standard of practice with respect to PAs towards optimal team practice beyond what Washington has right now. And we are actively meeting with the regulators there to try and understand the differences and to see what can be done to align ourselves with those states as they have a more liberalized practice. Finally, I'll address the IMG issue that was brought up. Again, we are creatures of the legislature, and last year they did pass a bill called House Bill 1129, and we are required to implement it, and we did. That created what we call the MD clinical experience, or MDCE license. Not pushing back too hard on this, but I flatly reject the idea that having an MDCE license for people who are trained physicians that happen to be in this state and unable to work except under that collaboration model would somehow force out PAs. The scope of practice for an MDCE is exactly that of their sponsoring physician, and that is not something that's going to be forcing spots away from PAs. They're not a mutually exclusive thing, and either way, we are still required by the law to implement that particular piece. So much of this, it may sound like I'm deflecting, but much of this is the responsibility of the legislature. They make these decisions. The practice standards that are implemented for PAs are in statute, as are now the MDCE license.
Okay, I just had a follow-up, just an FYI. The Northwest Medics is the second oldest PA program in the United States, and many of the staff have gone on to actually write the textbook for the entire nation, PA, A Guide to Clinical Practice. The gentleman that formed our group went on to form another little thing called the Peace Corps, just a little bit of history for us. Thank you for your time.
Very cool history. Thank you.
Thank you, Micah. And Dr. Yu had a follow-up question. She says, does California board staff have all the expertise to evaluate and investigate complicated cases involving standard of care?
I'm not intimately familiar with how California operates. I've spoken to them and I've done some research, but I believe they have medical consultants. They either have in-house medical consultants or they refer the cases out. In fact, I've seen their newsletter that consistently has calls for California physicians to, actually, I know that they have a very large list of experts that they rely upon. They have actually an outstanding program to train California physicians to be experts for the California board. So I think that's what they rely upon. They don't rely upon their board members.
And then Micah immediately raised his hand. You're self-muted. Go ahead.
So just to follow on that, the California Medical Board does have what is arguably one of the more impressive recruitment programs for clinical consultants. I know that in other states they use the lure of CE, free CE for the practitioners. Arizona is one of them, and they will pay a flat rate of like $150 an hour or something like that. The other thing to consider with California is they are so large that their attorney general's office has deputy attorney generals by region, and they sort of run the investigators and help make the decisions on what should be opened and investigated. So it's a very distributed model by necessity.
And then Dr. Chung, go ahead.
Yeah, can you hear me?
Yes.
Yes. Great. Well, I have a couple of comments. One is I feel like, Mike, this presentation and along with the one you gave before on the history of the medical commission, I feel like should be put into a module that should be included in orientation for all of our members or our commission members, commissioners, because I think it really does help give perspective to not just our work, but the variability of how things are done, and not necessarily that what we're doing is, the standard. There's perhaps lessons that we can learn from others, but I think it's very valuable, and I would suggest that it be created into some kind of an orientation module or a reference that we can use. The second is, I think about maybe 10 years ago when I used to practice in California, I was actually, I was going to comment on this before Dr. Yu asked the question, but I did serve as one of the consultants. And so what happens is they utilize subject matter experts as what they call expert witnesses or expert consultants, and they send cases to them to do a very detailed chart review, and they require a very detailed report. So you can't just make a little one-page assessment. I mean, these are like really detailed reports that they have a very standardized format, and you have to use a specific language. That said, they do pay their consultants pretty well. And then the board uses that information, or I guess the investigator or the staff uses that investigation to decide what to do. So there is a lot of clinical expertise that goes into these decisions over there.
Thank you, Dr. Chung. Melanie, if you want to go ahead.
Are you talking to me?
Yes.
Okay, so to circle back to Dr. Yu, all of the investigators at the California Medical Board are commissioned law enforcement officers. That's who they use as their investigators. And then once the investigation is done, then it does go to these consultants that are paid on a contractual basis. So the board members do not review those investigations, but they are done by law enforcement. So I think their investigators go out. I'm not sure if they carry badges and guns, but I think arguably they could. And that's what differs from our board.
Then Dr. Curtis?
So I was curious, Mr. Farrell, in the states where they have more regional boards, does that lead to disparity in what kinds of cases are investigated or how they're disciplined? Where, in our state, would he allow something different in parts of, Washington that we would not allow in others? Or
I don't know. That's an interesting question, Dr. Curtis. So in Vermont and New York and some other states in California where they operate regionally, how do they ensure consistency? I don't know the answer to that. I have not heard of that being an issue. In my reading and my research, I never came across that issue. But there must be some mechanism to ensure that the different disciplinary committees are making consistent decisions.
Thank you.
Are there any other questions? Doesn't look like it. All right. There are no other hands raised and no other questions in the question box. All right. You can wrap it up then, Mike.
Okay, it's a wrap. Thank you, everyone.
Thank you, everybody.